Blackpool Football Club Ltd.
Thank you. Mr. Collier. It's a little cooler this morning, which is good.
Councillor, actually, Collier.
Oh, goodness me. Again. That was the heat from my room rather than the court. But at least you've corrected me. Thank you, Mr. Councillor.
Delightfully cool, and I hope that we can make quicker progress as a result.
Thank you.
Lady, can I just begin by very briefly by making just dealing with one point. I think I may have made what was perhaps an overly generous concession yesterday in relation to the number of the claimant's case, respondent's case, on the number of boys who came from the School of Excellence to go on the tour. The evidence is simply not clear. The transcript, he's asked about that. If you wouldn't mind turning to the transcript bundle at page 34. This is cross-examination by Mr. Kent of DSN. And
Sorry, can you give me the...
yes, page 34 of the transcript bundle. The first question, perhaps, that Mr. Kent asks about this is between C and D. And Mr. Kent asks, but seeing what Mr. Sharp says, would it not be right to say that it seems to be a team that is recruiting from the Blackpool area geographically rather than from the School of Excellence? And then DSN gives a rather unhelpful answer. I wouldn't know because I wasn't in that year group. And then a little further down, he's asked again about Mr. Sharp's evidence, and Mr. Kent asks, I just wondered if that leads you, this is at letter F, to change your evidence that it was the Blackpool School of Excellence. No, because from my recollection at the time, the people that I was associated with in my year group, as far as I'm aware, all attended the Blackpool School of Excellence. Not quite clear what he meant by the people in his year group. But there it is. And then there's a series of questions and answers, which I won't take you through. But essentially, he's shown the photograph that we've looked at, and we now have the caption at the bottom. And I think actually the names from that caption come from this series of questions and answers, effectively, to find out what teams they play for. And he goes through them all. Mr. Kent takes him through all of those. And then at 36G, this line of questioning really comes to an end. Perhaps at F. I think somewhere we've seen there are about 20, I haven't counted the numbers here, but there are about 20 in the squad, is that right? Yes, approximately, yes. The YMCA was one of the leading teams in that area, and your ladyship will remember that that's the team that DSN played for. Yes, at the time. So, sorry, you said about 5 or 6. 4 or 5, yeah. 4 or 5, sorry, yeah. And then he goes on to deal with some Blackpool apprentices. And so, whether or not it's 1 or possibly 2, or whether or not it's more than that, it certainly wasn't all of them, because we know that some of the boys, such as Mr. Ellis's son, wasn't from the School of Excellence.
But that's not quite. These questions don't quite answer the point.
No, they don't.
Council, because we know, for example, by reference to the claimant, that he played for a YMCA team.
Yes.
And was at the BSE.
Yes, exactly.
And so the fact that 4 or 5 play in the YMCA team doesn't tell us anything.
No, that's exactly right.
About whether. But I mean, your starting point yesterday was that BSE had really dropped out of it. Wasn't the focus of attention.
That is still my position. I only correct this because I may have said that it was conceded that it was only 1 or possibly 2. And
right,
we
but
simply
the
don't
important
know.
concession is that this was not, if I can use colloquial terms, this was not a BSE team.
No.
That Roper took.
That's right. This was,
and that's common ground.
Yeah, that's right. This was. It may have seemed that way to DSN at one point, which is why I think he said something along those lines in his statement. But the reality was that, of course, all these boys who were at the School of Excellence also played for teams, because the School of Excellence was really no more than training evenings. Important though it was, I suppose, as a stepping stone. So they all played for clubs. Some of them played for the YMCA, the majority of them, which was the team that DSN played for.
And they had nothing to do with Roper.
No, because what was happening here, this is the Claimant's case, is that he was setting up a new team as he'd done before, and he was cherry picking, to use Mr. Ellis's words. It was Mr. Sharp's words.
Does he say that in his evidence?
DSN doesn't say
No.
that, but Mr. Sharp does. He talks about there being consternation amongst the coaches of the other teams, that what Mr. Roper was doing was cherry picking the best players. Now, that, of course, was after they returned from New Zealand.
Yeah. Okay.
So I don't want to make too much of that,
No,
because
no.
as Lordship rightly says, that isn't the way the case was being put, and it wasn't really the focus. And in fact, it may be why this wasn't pressed, because the numbers that came from the School of Excellence were really neither here nor there.
But it isn't a necessary implication that if he's setting himself up again, it is setting himself up as part of Blackpool, rather than setting himself up with a view to getting the best players who he would then make the most of in whatever way he thought best. Well,
I'm coming on to deal with that now, because the question that your ladyship raised was, where's the evidence to justify that statement that the judge made in paragraph 134, which is my next point, if I may.
Yes, please.
Can I just see if I recall? I'm sorry to keep talking.
No.
I think this is, for my part, I think this is central.
Yes.
I have written down, accepted that it was not a BSE team as such, though some may have attended the BSE probably between 1 or 2 or 4 and 5.
Well, we don't know.
All right. Numbers not known.
No, I mean the 4 or 5, of course, was a reference to the numbers that came from the YMCA.
Numbers not known. But otherwise, that's a fair.
That's right. And that follows, in my submission, from the fact that however many came from the School of Excellence was really not the way the case was being put. My lady, can I take you back then to paragraph 134, which is at page 106, just to remind you what the judge says about that. He says, when the boys got back from the trip, pause for a moment.
Could you give me that reference one?
Yes, it's page 106, it's paragraph 134 of the court bundle. He says, when the boys got back from the trip, Roper set up another team called Nova Juniors. Connecting with the earlier evidence, and I'll return, if I may, to that phrase, I've summarised the probability is that the earlier Nova Juniors team had outgrown youth football, and so this was a moment for Roper to reset the team by starting again with a new team of young boys. I infer that he used the New Zealand trip partly as a means of drawing boys in to join the fresh Nova Juniors, which was itself a means of bringing them to Blackpool FC until they reached the age when they could be formally signed up and tied in. And as the judge makes clear, he's inferring that from the evidence that he's heard, and I've checked, and there is no direct evidence of some kind of preconceived plan, either involving Blackpool or even just involving Roper, to set up the Nova Juniors when the party of boys returned from New Zealand. There isn't any evidence of that. But I submit that conclusion, inference, was a perfectly proper one to be drawn from the evidence he had heard, and entirely reasonable and well within the kind of reasonable conclusions which he could have reached on the evidence. And of course, he having heard the evidence, he was best placed to reach. The position on the evidence is that Roper ran Nova Juniors as a feeder team for Blackpool before the trip to New Zealand, some time before, a year or two it seems, I'm not clear exactly on dates. And he ran a Nova Juniors team afterwards in exactly the same way. The only difference is that one was based in South Manchester and the other was based in the Fylde And there's no evidence that his role, particularly in the youth setup, differed in any way in the between those two teams. To the contrary, he was always viewed as a central tenet of the Blackpool youth setup. And I do submit that that's a finding that the judge made, having heard the evidence, and with respect, you should only interfere with this finding if it is effectively perverse or untenable on the evidence. Clearly it was, I submit, well-reasoned, and more than satisfies the balance of probabilities threshold that the tour was linked to Blackpool's youth operations. And whether or not in that paragraph 134 the judge was inferring, as I say, that this was part of a preconceived plan to set up Nova Juniors again after the New Zealand tour, or, as I would suggest, much more likely that he was simply saying that the way in which Roper decided to carry out his role as a recruiter of the best players to Blackpool, really, my submission doesn't matter. Roper had a role to play at the club, a central role to play at the club, and it was left largely to him to decide how best to achieve what was incredibly valuable for the club. And as my own friend put it yesterday, the NHS may employ a surgeon to carry out surgery, but they don't instruct him or her on how to carry out that particular operation. The same is true here, and it also fits generally with what I'm going to go on to say about control, about the ingredient of control in limb 1 of vicarious liability. And as I say, I'll come back to this, but when she was dealing with the significance of the degree of control exercised in the Barclays Bank case, Lady Hale said that in such a situation you might be able to tell an employee, inverted commas, what to do, but not how to do it in this day and age. The judge heard the evidence and decided that this was effectively a reprise of the arrangement which had existed for years and which had been so successful. And I'm going to come on, if I may, just briefly to look at some of that evidence as to why that conclusion was a reasonable and appropriate one.
But, Mr. Counsel,
Yeah.
Isn't there a difficulty here? Because if you're conceding that there's no evidence that this was in contemplation of Blackpool or Roper prior to the trip, but it was obviously formulated at some time by Roper that this was an opportunity to feed Blackpool Football Club.
Yes.
You're still missing a vital step, aren't you? Because you can't say that by virtue of the fact that he takes advantage of the trip that is not sponsored by Blackpool Football Club, but subsequently he takes that step, that they are then retrospectively liable?
Well, no, his role at the club was to recruit the best young talent, and in a sense he chooses how to do that, the methods to use.
So he chooses to take a group of young men to New Zealand and Thailand.
Yes, with respect, considerable support from the club.
Well, you say that, but that's one of the things we've got to determine. Counsel, and you haven't really taken us to the evidence that shows that yet. For my own part, I don't think you have.
Well, let me do that and then come back, if I may, to compare before and after, because I say that's another reason why it's a reasonable inference for the judge to have drawn. But let me deal with that first.
Yes.
When Mr. Roper first came to recruit players for the tour, he brought Chapman and Hurst with him to see Mr. Sharp to give Roper credibility. So they both came in order to give that visit, to add weight, reassurance, credibility to Mr. Roper when he asked Mr. Sharp, who was, of course, a coach of one of the teams from which this Nova Juniors team was to come from, and from which the New Zealand players, the players who went to New Zealand came from.
Well, he approached him on the touchline.
Yes.
This was when he approached on the touchline with Hurst and Chapman.
Yes.
And Sharp's impression was that Frank Roper was also associated with and worked for Blackpool Football Club. In my opinion, they were there to give credibility to Frank Roper. Some of the Polton youth boys went on to Nova Juniors and then to sign Blackpool schoolboy forms. Roper persuaded Sharp to help him get families on side for the 1987 New Zealand trip, which I will come back to below. So that's when they turned up with Roper. It wasn't a pre-arranged meeting. It was, they were at a football match with Roper.
Well, I think Mr. Sharp. Let's take you to his statement. Yes, in his statement, it's a supplementary bundle, page 36. Mr. Sharp says, first, page 36.
Thank you.
Supplementary bundle. He says, I first met Roper whilst I was managing an under-13s team in Blackpool called Polton Youth. During a game in early '87, I think he later corrects the date to '86. I guess that must be right, because that's when they went. Roper approached me on the touchline with two men that I knew to be scouts from Blackpool Football Club, Jack Chapman and Bill Hurst. Due to the fact Roper was with Chapman and Hurst, who I knew to be Blackpool Football Club youth coaches, my impression was that Franker was also associated with and worked for Blackpool Football Club. And then there's then the passage which your ladyship has referred to from the transcript. They were there to give credibility, to give the visit the support of Blackpool Football Club.
Well, that's what Mr. Sharp considered their presence did.
Yes.
But where's the evidence that that's the purpose of their approaching Mr. Sharp in that way? So, of course, the judge had evidence upon which he could infer that certainly Roper took advantage of that. And certainly Mr. Sharp perceived, well, this isn't just a fly-by-night. I don't know him from Adam, but I do know that those two are from the football club. But if we then go on to see what the judge says, I'm still having some difficulty to see what, but perhaps you're going on. I'm sorry, I'm interrupting
No,
too much.
not at all. It's helpful, obviously, always to know the way.
Yeah, well, it's a genuine point that I'm seeking to unravel.
There are a number of points, and this was one. And the judge accepted Mr. Sharp's evidence about that, and he considered that that's why they had come. And this was Mr. Chapman, who was the youth coach. He wasn't a scout, together with Mr. Hurst. In fact, Mr. Hurst's evidence was it would be rather unlikely that we'd both be in the same place at the same time, because that's not the way we operated. They came to give it the stamp of approval.
Well, this was a football match.
Yeah.
A youth football match. So both of them, quite independent of Roper, would have some interest, presumably, in what was going on the field, in view of their roles with Blackpool Football Club. But it's your link with and the judge's link with the trip.
Yes, and this is a Polton Youth, though. This is a local team. There they are. They all turn up, all three of them. And Roper, who's a man they don't know, asks a man that Mr. Sharp doesn't know, asks whether four of the boys go on the tour to New Zealand.
Of course. And if you were a parent, you'd say,
yeah,
Certainly not.
yes.
Quite.
Yes, but yeah, okay. But anything that you can do in regards to that further, please
Well, that's the first point.
Yeah.
Second one is there were then a number of meetings, not just one, but a number of meetings, and those meetings took place at the football club, social club.
At the Tangerine.
Tangerine Club.
Yeah.
At one of those meetings, at least, if not more, Mr. Ellis was there, and on one occasion, certainly, he stood up to support the tour in the sense that he said, "My son is going to go on it."
Yes, there's plenty of evidence.
Plenty of evidence about that. Yes, he says that he went there as a parent, but not as a representative of Blackpool. But with respect, he was the manager of the club. He was the face of the club. The person who parents would think was the most important person at the club in terms of the ambitions that they may have had and their son may have had for a future football career.
But the only thing he didn't say is it's a Blackpool trip.
No, he doesn't say he said that, but he says, I can see why the parents would have gained reassurance. He doesn't go further than
But I'm sorry to be difficult, but that is quite an important omission, isn't it? Because, yes, same way as with any of the household names today, if they said their son was going on a trip, that would lend football-keen parents some assurance. But it doesn't mean it's their club's trip.
Well, no, I mean, the club were not funding the trip. This was a trip being organised essentially by Mr. Roper, who was known as a Blackpool Scout. I'm not suggesting that any of these points are necessarily conclusive on their own, but they build up the picture that this was part of the Blackpool recruiting, and that was part of it. And your Lordship is right, of course. If the evidence had been that he stood up and said, no, this is a trip being done on behalf of Blackpool, then the case would be a stronger one.
But it might also be stronger, Mr. Counsel, if he'd stood up and say, look, I haven't got any children who are attending this tour, but I can tell you, as manager of Blackpool, I think it's a good opportunity for your boys. That's what he said, but this time it was on the basis that my son is going because of this experience.
Yes.
So, I mean, we can't get around the relationship quotient there, can we? And that's what he was trying to reassure other parents. I'm a parent, your parents, because, as it turns out rightly, that there was concern, wasn't there?
Well, there was, and of course, the major concern, understandably, these parents had was whether or not there was some sort of drugs involved, as far as I can understand the evidence. And so he's providing that reassurance in that context as well. Yeah. And how does he do that? Well, he does it, I suppose, from the fact that he's sending his son it, which what's that going to say to parents? He knows Roper, we can trust him. So that's another matter. And the next, of course, is that 4 apprentices, now these are boys who were signed under a YTS contract, I think, if that was in existence at the time. 4 apprentices went on the tour to help. And the last one is that Blackpool made a contribution to the tour at the request of the club manager. I've taken you, I think, yesterday to the evidence about it.
You did.
From Mr. Chadwick. But can I just go back to when I'm dealing with why it's a reasonable inference for the judge to draw? He had evidence, a good deal of evidence, as to how the team over juniors was run, and the benefit that the club got from Roper running that team when it was in South Manchester, and he also had a good deal of evidence of how it was run when it came back from New Zealand, if I can put it that way. The first incarnation, as I say, was the South Manchester team. Numerous witnesses, nearly all the witnesses, not all of them, said that this was a feeder team for Blackpool. run by a scout working for Blackpool. I'm not going to take you to the references in the judgment, but he goes through each and every one of those witnesses. Paragraph 103, he sets out the evidence from Mr. Wright. Then at 104 and 7 from LDX. And at 108 from Greenall. And then paragraph 109 from CFS. And paragraph 114 from ANF. Perhaps I could just take you to one of those, paragraph, the first one, paragraph 103, right, which is page 98. He summarises Graham Wright's evidence on paragraph 103. Recruited to Roper's Nova Juniors team in the Stockport area when he was 12 or 13. Played for them until he was 14. Roper was locally known as a football scout for Blackpool. He had a sports shop in Blackpool. He remembers Roper taking them to Blackpool. I would imagine it would have been a way of getting us interested in Blackpool Football Club, as Roper was well known as having a connection with the club. And then a little further down, he said Roper was a scout for Blackpool FC. Shop was nothing to do with it. He only knew Roper to be involved with Blackpool Football Club. And that was how Mr. Ellis understood it. And Mr. Ellis's evidence about that is significant, not just because of what he says, but of course because of who he was. And can I take you to his witness statement in the supplemental bundle, at page 110. Mr. Ellis says, when I joined Blackpool in June 82, the youth team manager was Jack Chapman. Paul Stewart was already signed to the club, as was David Bardsley. Paul and David went on to play in the Premier League and for England. They'd been brought to the club as schoolboys in the 1970s by Frank Roper, who I was informed was a scout for the club, who'd been running a feeder team for the club for a number of years prior to my arrival as manager, and who Paul and David had played for together. Roper had a reputation within the club, including with the board of directors, for bringing good quality youth team players into the club from the feeder team he ran in the Manchester area. And then he says, and I say significantly in paragraph 7, that Nova was a feeder team solely for Blackpool, and Roper didn't introduce players into other clubs within the northwest or further afield. In those days, we didn't have the structure within football that we do now. And then he refers to the rule about not being allowed to sign young boys until they were 14. And so the practice of Blackpool and other clubs, therefore clubs like Blackpool, relied upon people like Frank Roper running feeder teams like Nova Juniors for recruitment of schoolboy footballers who could then go on and sign schoolboys and hopefully when they were older as apprentices, full-time professionals, as was the case with Paul, David and several others. And then at 9, he says, as far as I was concerned, Frank Roper was a scout for the Manchester area for Blackpool and the coach of an affiliated feeder team. And then he talks about him having the freedom of place. And then just finally, at paragraph 11, he says, I'm not sure how long he'd been associated with the club for, or how long he'd been a scout for the club and running the feeder team before I became manager. However, I do know that his association continued for most of the time that I was the first team manager. And he explains that in the next paragraph, where he says, I do know he was still around in 85, 86. That, of course, is the season when this tour took place at the end of the season, as he arranged some trips to the Far East and New Zealand that my late son Tim went on. I would say he was probably still around in 87, but I can't remember for certain if he was still working for the club as a scout. and remained associated with the club when I left as manager in March '89. So it looks as though he was still working in that same position in 1987, but he can't remember whether he was as late as '89 when Mr. Ellis left. And of course, '87 would have been after the trip to New Zealand, when he would have been running the club, the team Nova Juniors, from the filed area. And the evidence, of course, plenty of it, was that players were invited to come to the club, to meet players, watch matches, and all of this was a means to keep them connected to the club. And his lordship dealt with that in his judgment of paragraph 112. That's page 100 in your core bundle. He's there dealing with the evidence of CFS, in fact, and he recounted that they would go and watch matches 4 lines down. When watching matches, Roper and I would sit in a private box with other boys, players from the club and Blackpool Football Club officials. Jack Chapman would sit with us in the private box. And he perhaps qualifies what he means by the box, more of a designated corner of the stand than a modern box. It was known as Chapman's Corner. And then when the time came, these boys signed schoolboy forms, and Mr. Roper was remarkably successful at that. Your ladyship will recall the evidence that I took you to yesterday from CFS. 7 out of 9 of the core players in 1 year went on to sign schoolboy forms. And my submission for all of that, it's quite clear that Blackpool gave him a good deal of leeway about how he ran its feeder team. And nor was there anything secretive or underhand about any of this. Everyone knew he was a scout for Blackpool. And Blackpool were keen to support him in running the team because, of course, he was a very important part of the club.
What's the significance of the fact that some people who he scouted went to other clubs?
Inevitably, 1 or 2 decided that Blackpool was not for them. It would happen in any arrangement because there's no commitment until they sign schoolboy forms. And of course, some of these boys would be playing at school. They would be playing in other ways, and they might be seen, and they might be tempted away. And we saw that. 1 or 2 of them didn't go on. You didn't join Nova Juniors and sign on the dotted line, and now you're part of Blackpool. That was why the cocooning evidence is so important, to make them feel belonged. And the evidence that we have as to how the Nova Juniors operated after New Zealand is the reason why the judge was justified in the inference that he drew when he used those words, connecting this with the earlier evidence. Because the new team operated in exactly the same way, even with the same name. The only difference, as I've said already, was that it was operating in Fylde and not South Manchester. Best evidence, perhaps, that the judge heard about that comes from Mr. Sharp, whose son, of course, went on to play for Nova Juniors, having come back from New Zealand, although Mr. Sharp had concerns that his son would be pressured into joining Blackpool. Paragraph 50, supplemental bundle, page 38. Bottom of the page, paragraph 15. Mr. Sharp says, when they returned from the trip to Thailand, Roper started up Nova Juniors in the Fylde area. This team was based around the boys who'd been on the New Zealand tour And I recall that Nova Juniors would play some of their games at the Blackpool Football Club training ground. The creation of Nova Juniors caused some consternation amongst the Fylde Youth Alliance League, as Roper was poaching the best players from this league, including 4 lads from Polton Youth, one of whom, of course, was his son. I remember that when the boys returned from New Zealand, I had the impression that they wanted to continue to play with each other. Kevin, his son, also wanted to continue playing with Nova Juniors and left Polton Youth to do so. The boys playing for Nova Juniors would have been between approximately 12 and 15 years old, and then he recounts how on one occasion he drove the team to Aston Villa in a minibus with Blackpool on the side. Then paragraph 17 talks, again, in exactly the same way, with the team being taken to watch Blackpool Football Club, some of the parents going as well, and sitting in that same area, known by some as the Chapman Corner or whatever it was, and how on one occasion somebody who shouldn't be there, a coach from another team, was sitting in the same section, and Roper's reaction to that, and how the youth coach, Jack Chapman, would always go to meals arranged for the boys at the seafood restaurant in Blackpool. And then finally, the culmination in this arrangement, namely the signing of the boys. In Kevin's case, of course, it didn't happen. And it happened, the circumstances were rather bizarre because he was being asked to sign when he wasn't 14. And you'll see it set out there, Mr. Sharp describes that. Mr. Chapman approached him, said he'd like Kevin to sign schoolboy forms. Mr. Chapman queried that. Mr. Chapman's response was to say that he could sign the forms early and they'd then be kept in the safe until he was older. And then he sets out Mr. Roper's reaction to Mr. Chapman having done that. And so the process was precisely the same. This was all part of the role, the work that Mr. Roper was doing for the club. And
does it matter, Ms. Counsel, that these boys were also playing for other teams?
Well, they weren't. They might have been playing for school
according
teams.
to Mr. Sharp. After playing for Nova Juniors for about a year, Kevin began playing for Blackpool schoolboys.
Yes.
He was good at football.
So
It was separate from Blackpool Football Club. It was a team made up of players of school age in the local area.
Yes.
So it wasn't the school team, it was a bigger team than that.
Yes.
At around this time, other scouts from other clubs became interested in some of the boys, but Roper was keen for the boys at Nova Juniors to sign with Blackpool. And there's another point which I think is associated, so you might want to answer both
Yes.
at once. If you look at paragraph 136 of the judgment, there seems to be some inherent contradiction between 135 and 136, because although DSN says that as a result of turning down the Nova Juniors invitation, my parents told me I was not asked to play for Blackpool School of Excellence anymore, and that the judge accepts that and he makes sense to him. In 136, there's correspondence from 1987 of a final report from Blackpool School of Excellence, which was incorrect because of its rating of DSN's marking and attitude. And DSN's mother rightly got in touch and said that the YMCA for which he played and Chapman would be willing to confirm this if necessary, and the headmaster agreed. And the judge infers that perhaps this had been Roper's interference. But both the YMCA and Mr. Chapman were willing to wipe it clean and no harm was done. So it seems to be that this football feeder team may have been one of several.
Certainly were other feeder teams.
So in respect of the coaches of those teams as well, if they had introduced players to Blackpool, would they have the same relationship as you say Roper did?
well, we simply don't know how closely they were connected or the way in which they operated. But there certainly was evidence that there were others running feeder teams. And we know that, of course, Mr. Roper was running a team in South Manchester. And, I think the evidence was that was his area.
Was it at the same time as the...
No, earlier. So there were definitely other feeder teams.
All right.
But just going back to your first point, which was the reference you gave us to Mr. Sharp's evidence. My reading of that, so this is page 39 of the supplemental bundle.
Yes.
My reading of that was that Kevin left Nova Juniors and went to play for another team. Because certainly the whole point of the Nova Juniors was to entice the best players away from the teams that they had been playing and keep them at Nova Juniors.
Well, I don't know about that, because if you read 21, subsequently, Kevin said that Roper was going to Thailand on a business trip and wanted him to go with him. I told Kevin it was completely out of the questions. This was not a football trip, and if he did not go, but the 3 others did. And he did not go, but the 3 others did. I heard from other parents of Nova Junior boys that something had happened.
Yeah.
So it looks as though he did continue his connection with Nova.
Well, it sounds like, if I may say so, that he went to play for another team, and this was a means by which perhaps Roper was trying to entice him back. He was,
well, I don't know, because it was after the, after the trip, the team disintegrated.
Yes, after the second trip, which didn't involve very many boys, as I understand it.
No, which
wasn't to New
seems to have
Zealand.
given rise to a...
So they wouldn't have been playing.
Yes.
They wouldn't have been playing football either.
Yeah, thank you. Sorry.
And then that was the evidence of Mr. Sharp. And then finally on this, there was the evidence of Mr. Bradshaw. And that's significant in my submission, because he, I think, unlike all the other evidence, was in the unique position of having played for Nova Juniors for 3 years from 1982, so the South Manchester Nova Juniors, when it was South Manchester based, and then going on the New Zealand tour as an apprentice. His witness statement is at Supplemental Bundle 93. And at 95, paragraph 4, 94, I'm sorry, paragraph 4, Bradshaw says, I first met Roper in around 82 when I was approximately 13 years old. He ran a team called Nova Juniors, and he sets out how he first got involved with that team through the father of one of his friends. Based in the Stockport area, played from them for 3 years in paragraph 5. And then he describes what Roper was like, and you'll see at the bottom of paragraph 6, he says, once I left Nova Juniors, I signed with Blackpool Football Club as an apprentice and continued to come into contact with Roper, seeing him around Blackpool often. I won't go through all the evidence because it's the same evidence again, but if you look at paragraph 11, he describes being taken to matches and so forth, how third sentence, Roper would normally take Nova Juniors players, but occasionally he'd bring some players that we didn't know. These boys would be introduced to us as potential new players. And then in paragraph 14, he goes on to give some detail about Roper at Bloomfield Road, Blackpool's ground, and he describes he gives his recollection of Roper having a room there. That was, I think I referred to it briefly yesterday. 4 lines down, paragraph 14. I remember that Roper was quite proud of his room, and he'd have drinks in there, and then visits to the players' lounge and so forth. And then at paragraph 20, he goes on to deal with the New Zealand trip. I went on the trip to New Zealand with Roper and a number of boys from Nova Juniors in around June 87. Now that must be not quite right, of course, because the evidence was that Roper set up Nova Juniors immediately after the trip. So the boys weren't from Nova Juniors. Does your ladyship have it? Paragraph 20.
20, I'm sorry. I do now. Yes, thank you.
Page 98. He says, I went on the trip to New Zealand with Roper and a number of boys from Nova Juniors in around June 87. Now that might be, of course, how they became, but Nova Juniors hadn't been set up then. I was an apprentice at the time. Again, he makes that same error in paragraph 22. The boys on the trip were from Nova Juniors and would have been around 11 or 12 years old. I didn't know them particularly well as they were quite a bit younger than me. I went on a trip to help look after the younger boys, and as the trip was in June, I didn't have to take any time out of playing at Blackpool. And then he just names the other apprentices, and they're all, I think, in that, 3 of them are in that photograph. He then describes going on 3 international trips with Roper as part of Nova Juniors. And then at 24, finally, he says, during the trip to New Zealand, so this is the trip that DSN went on, the older lads and I would watch the younger boys' matches. I remember that Kevin Sharp, Mr. Sharp's son, of course, and Jamie Forrester were on those trips, and that they were put under some pressure to sign for Blackpool Football Club. Can't really remember the names of any of the other lads. And then he talks about how he came in contact with DSN, whose name is, for some reason, not anonymised line of the statement.
Does this witness either say, or by necessarily implication say, that this was a Blackpool Football Club trip?
I don't think so. He calls it a Nova Juniors one. He talks about the boys having come from Nova Juniors.
As to which he's wrong.
He's wrong about that, yes. Certainly he's wrong about that. The boys, yes. He was, of course, a Blackpool apprentice. And I think there's evidence, I'll be corrected if I'm wrong, that the apprentices were present at the meetings at the Tangerine Club.
But that cuts both ways anyway, because he went out of season.
Yes.
So he wasn't going as a Blackpool apprentice. He wasn't a Blackpool apprentice, but he makes the point which you took us to, which we looked at yesterday, which was that he was out of season, so he didn't have to take time out of Blackpool.
Yeah. That's true, although, of course, contractually, he would have still been an apprentice. Pulling all of that together, I submit that it's hardly surprising that the judge, who of course heard the evidence, concluded that the tour was part of the process of recruiting the next generation of young players. Actually, there's one piece in Mr. Bradshaw's evidence which I meant to take you to, which might explain why there was a gap. It's at paragraph 7. If you go back, I should have taken you to that. At paragraph 7, so this is after he stopped playing, which was in about 1985, I think. After 3 years, I stopped playing for Nova Juniors. Roper disappeared, and I know that he had financial difficulties with his prison. So this is in between time. This is after he'd been running the Nova Juniors in South Manchester, but before the New Zealand tour. Roper had a shop selling sports kit in Blackpool. I knew Roper got into difficulties because another lad who'd also played for Nova made me aware of this. Roper had told his customers that he'd had a really good deal coming and asked for cash up front from those who wanted a deal, and you'll see the evidence. And there may be some significance. That might explain why it was that there was this gap between Nova Juniors, South Manchester, and Nova Juniors final.
Roper was convicted in the meantime, wasn't he?
I think he was, yes.
So, was he sent to prison?
I'll have to check that. I know that the judge deals with the convictions right at the beginning of his judgment. I'm not sure whether he...
So we've got three possible explanations. We've got Mr. Sharp saying that something happened on the subsequent tour and the team disintegrated.
So that was later.
That's later.
Yeah.
So,
So
he
when
was.
you-
I'm terribly sorry.
I just wonder, paragraph 7, what year do you say that is referring to?
Well, Mr. Bradshaw starts his...
98.
On his chronology, it must be about 1985.
yes, about 85, shortly before this. So it wasn't long gap.
I thought he first met Frank Roper in 82. He then played for 3 years. So that takes you 85.
Yes.
So 3 years after he stopped playing for Nova Juniors would be 88. Isn't it? Or is
No,
my
no,
maths even more?
He starts playing in 82, I think. He plays for 3 years till 85.
85.
And then, of course, this was 1986, so the gap is quite a short one when Roper disappeared.
Well, he was last convicted in 84, so it can't have been because of a prison sentence
No, it
that he
can't.
disappeared.
Um,
But neither could he have been, if he did go to prison, coaching the Nova Juniors team.
well, depending upon the sentence, I suppose.
Yes.
This is long before any kind of checks, I one suspects. I'm sure that we may be able to find out what the sentence was.
Not to worry.
I don't.
It just accounts for the
Yes, I don't recall
chronology.
ever being mention of a
No.
prison sentence. So there is a short period of time when, according to Mr. Bradshaw's recollection, Roper disappeared, and then he's back again, and setting up the tour, and Nova Juniors filed to follow. And I do say with respect that from all of that evidence, the judge was quite entitled to come to the conclusion that the tour was part of the process of recruiting the next generation of young players. Some of the submissions that the learned friend said, if I may say so with the greatest of respect, is attempting to persuade the court to retry the case on the transcripts and the statements. And I do say that the court should be slow to overturn this finding, and indeed findings of fact generally, where the judge has cogently and in a well-reasoned way set out his explanation for those findings, and of course where the judge was best placed to make the assessment of the evidence. That's taken me a little bit longer than I'd intended, but it's a very important point. So can I then, putting that to one side, just very briefly, first of all, summarise my submissions I'm going to make on limitation of vicarious liability, and then, if I may, although of course correctly the judge dealt with limitation first, because one mustn't put the cart before the horse, or rather to do it the other way around, putting the cart before the horse, deal with vicarious liability first, because that's what we spent most time dealing with yesterday. Just in summary, limitation first. The appellant's problem, in my submission, is in this appeal, is that when dealing with the exercise of the discretion under section 33, the trial judge held that it was for practical purposes impossible for the claimant to bring a claim earlier, having regard to the effects of the abuse on him. And that's a finding which cannot now be challenged, and quite properly the learned friend hasn't gone near it, because of course the appellant didn't get permission to challenge that ground. So what follows from that in terms of discretion, on limitation discretion, is that the DSN could not have brought this action any earlier than he did, and as such any delay is not his fault. To the contrary, it's the index abuse and its consequences, namely the psychological and psychiatric effects upon DSN, which provide the reason for bringing this claim outside the primary limitation period. And the second point I make about limitation is that in the appellant's skeleton argument with respect, they apply the wrong test in relation to section 33. The test is not whether and to what extent the defendant was prejudiced in meeting this claim. It's a much broader one than that. It's whether, taking into account all the circumstances, on balance, it's just and fair that the action should proceed. And that, if I may say so, is a crucial distinction overlooked by the appellant's skeleton argument. And in circumstances where the judge addressed his mind carefully to the section 33 issues, we would say that the appellant now faces an impossible task in seeking to persuade this court that the trial judge's exercise of discretion was so wrong that it should be overturned. In fact, we would say the trial judge reached an entirely appropriate and correct conclusion in extending time under section 33. So I'll come back to all of that if I may at the end. Then turning to vicarious liability, first of all, the trial judge again applied absolutely the correct legal test. The law in respect to vicarious liability has not moved on or developed in any way since the trial judge handed down his judgment. Although, of course, those two Supreme Court decisions of Morrison's and Barclays are important, they don't purport to set out any new principles in relation to vicarious liability, as is confirmed in a recent Court of Appeal analysis in the case of BXB, Barry Congregation of Jehovah's Witnesses, and BXB. And what the appellant really is doing with respect, in a, if I may say so, very skillful way, is attempting to undertake an extensive analysis of the evidence. And of course, inevitably, that analysis is bound to be selective. And that approach, in our submission, is telling, because however it's dressed up, this appeal amounts to a challenge to the trial judge's core findings of fact. And there's simply nothing about those findings or conclusions which could be said remotely to be perverse. We say his findings are unimpeachable and appropriate, and that he was right when he considered that the appellant should be held vicariously liable for the sexual abuse by Mr. Roper. So can I just then elaborate in a little more detail about vicarious liability? First of all, the law generally. The court has been taken already by Mr. Kent very fairly through the leading authorities. The legal test, of course, set out in the various claimants' case is the two-stage test, whether the relationship of the tortfeasor and the defendant, so Roper and Blackpool, is one that is capable of giving rise to vicarious liability. And then if it is, the second stage, the connection links that relationship and the act or omission of the tortfeasor, in this case, of course, the abuse by Roper. And as I've said, the Supreme Court decisions in the Morrison's supermarkets case and the Barclays case don't alter that two-stage test. Might I just take you, I've just briefly referred it to the judgment of Lady Justice Nicola Davis in the recent case of BXB, paragraph 71, which is on page 274 in volume 2 of your authorities bundle, where she deals first of all with the case of E, the very well-known judgment, of course, of Lord Justice Ward. And then in the second sentence, the Supreme Court decisions in Barclays and Morrison's did not change the common law on vicarious liability. Indeed, she then refers to a paragraph from Morrison's judgment of Lord Reed, which stated that previous Supreme Court authorities had not intended to effect a change in the law of vicarious liability. Quite the contrary. In each case, the court applied existing legal principles. And so just briefly, in summary, applying those two limbs, first of all, before I look individually at two grounds 7 and 8, Roper was one of a number of people, mostly unpaid volunteers, as Mr. Johnson accepted in his evidence, who worked for the appellant. And I say worked for without meaning employed by, but did work for the appellants. In his case, by acting as a scout and also as a coach of an essential source of young talent, a feeder team which supplied a significant proportion of the young footballers who went on to sign up schoolboy forms at the age of 14, some of whom later went on to become Blackpool players and some of whom fell by the wayside. Roper's close links to the club set out in detail in the judge's summary of each of those witnesses' evidence in a long section of his judgment between paragraphs 93 and 157. And I do say that evidence didn't simply consist of impressions, as friends suggested, of the witnesses, nor just of what Roper had told the witnesses, but direct evidence of Roper's role at the club and of the high regard in which he was held. He was a scout for Blackpool. The judge heard that time and again from many witnesses. He was somebody who provided talent exclusively to Blackpool. That was the intention. And of course, as I said already, one or two went elsewhere. It was his position at the club which gave Roper the power and hold over the boys in his charge, the aura, as Mr. Ellis put it in his evidence. The judge was perfectly entitled and correct to conclude that the relationship between club and Roper, the first limb, one from which both he and the club benefited, was capable of giving rise to vicarious liability. The judge put it in this way, and was entitled to do so. Roper was part of Blackpool's workforce in the youth setup. That's paragraph 161 of the judgment. And moving on to the New Zealand trip, the judge was right to conclude that the New Zealand trip, although, of course, I accept, not officially a Blackpool tour, was part of that recruitment process. We spent some time this morning dealing with this. I won't repeat again the evidence of Mr. Ellis and of Mr. Sharp and of the 4 club apprentices, or at least the one that we heard from, Mr. Bradshaw. Mr. Ellis's and Mr. Sharp's sons didn't choose to join Nova Juniors on their return. Sorry, Mr. Sharp's son did, in fact, for at least for a time. Mr. Ellis's didn't. And significantly, when DSN chose not to, he was removed from the club's School of Excellence, telling evidence, we would say, of the close links between between Roper's team and the club, and the extent of Roper's influence. DSN, of course, for obviously understandable reasons, didn't want anything to do with Roper when he came back and wasn't going to join any team which he ran as a result of the abuse he'd suffered. As a result, his ambitions at Blackpool were ended. And the judge, applying the law correctly, was, and there's no challenge to the way he applies the law, was right to come to the conclusion that the abuse of the claimant on that tour was so closely connected to the relationship between Roper and the club as to make it just to hold the appellant liable. So, dealing first of all then with stage 1, my own friend's been through all of this, so I'll take it quickly, but the stage 1 of the test, of course, as defined by Lord Phillips in Catholic Child Welfare Society case, is the relationship of the tort fees and the defendant is one that is capable of giving rise to vicarious liability. As the appellant accepts, the defendant in the tort fees need not have a relationship of actual employment, and in that case V, Lord Justice Ward's judgment in E, in English Providence, stage 1 of the test was said to be established where the relationship was a relationship akin to employment, or capable of being established where the relationship was a relationship akin to employment. As Lord Justice Ward said, won't take you to the authorities bundle unless you'd like me to, in page 119, his paragraph 73, the test I set myself is whether the relationship of the bishop and Father Baldwin, in that case, is so close in character to one of employer that it is just and fair to hold the employer vicariously liable. And then, in fact, in the paragraph immediately above that, Lord Justice Ward set out what he described as hallmarks of a relationship between employer and employee. Can I take you to that? It's the second authorities bundle, page 118. These are the 5 hallmarks. Paragraph 72 on page 118, he sets out those 5 hallmarks. First, control by the employer of the employee. Second, control by the contractor of himself, because the greater degree of control that the tortfeasor retains, the less likely it will be controlled by the employer, or the employer in inverted commas. Thirdly, the organisation test, how central the activity is to the enterprise. This involves the question how far the activity is a central part of the employer's business from the point of view of the objectives of that business. And then fourthly, the integration test, the organisation test in the second sense of whether the activity is integrated into the organisational structure of the enterprise. And then fifth and lastly, is the person in business on his own account, the entrepreneur test. This is not really a separate test, and it's intimately involved in the other 4. In the various claimants' case, the Christian Brothers case, Lord Phillips identified the policy reasons behind imposing liability on third parties for the wrongs of others. Would you go, please, to 153 in your in the same bundle? Lord Phillips sets out at paragraph 34. He's looking here specifically at relationship, employer-employee relationship under a contract of employment. The employer will be vicariously liable when the employee commits a tort. There's no difficulty in identifying a number of policy reasons that usually make it fair, just, and reasonable to impose vicarious liability when these criteria are satisfied. Then he sets out 5 again, likely to have the means to compensate, and the question of insurance. Tort will have been committed as a result of activity being taken by the employee on behalf of the employer. 3, the employee's activity is likely to be part of the business activity of the employer. 4, by employing the employee to carry on the activity, that would have created the risk of the tort committed by the employee. And then 5, echoing the factors that I've just read out, the employee will, to a greater or less extent, have been under the control of the employer. And then it paragraph. And then, if I may take you away from those cases, both of which, of course, I think were in 2012, to Cox, the decision again of the Supreme Court, in which Lord Reed gave the judgment. He, having extensively reviewed the leading cases, looked again at those considerations, those 5 factors that had been set out by Lord Phillips in the various claimants' case. Paragraph 21, please, of his judgment, page 175. He's in paragraph 20. He set out above that in paragraph 18, in fact, cited that passage that I've just read out. And then at 20, he makes the point that 5 factors which Lord Phillips mentioned are not all equally significant. And then he analyses each one before coming at paragraph 21 to the 5th of those factors, that the tortfeasor will, to a greater or lesser extent, lesser degree, have been under the control of the defendant. And he says that no longer has the significance that it was sometimes considered to have in the past, as Lord Phillips immediately made clear.
But that's because the boundaries between employer-employee and other more modern arrangements which are designed to have the same effect but don't use quite the same method,
Yes,
have to be taken into account.
yes,
But we're still talking here, aren't we, about the indicia of employment which give rise to, or are capable of giving rise to vicarious liability.
your Lordship is exactly right. And of course, this isn't an employment. This is akin to employment situation. And I think what he comes on to say here is, if one reads paragraph 21, the ability, as he explained, as Lord Phillips explained in paragraph 36, the ability to direct how an individual did his work was sometimes regarded as an important test. But it's, reading on to the next sentence, not realistic in modern life to look for a right to direct how an employee should perform his duties as a necessary element in the relationship between employer and employee, nor indeed was it in times gone by. If one thinks, for example, of the degree of control which the owner of a ship could have exercised over the master while the ship was at sea. Accordingly, as Lord Phillips stated, the significance of control is that the defendant can direct what the tortfeasor does, not how he does it. So understood, it's a factor which is unlikely to be of independent significance in most cases. On the other hand, the absence of even that vestigial degree of control would be liable to negative the imposition of vicarious liability. And of course, as your Lordship rightly says, what they're dealing with here is the employer-employee relationship. This isn't an employer-employee relationship. And the degree of control, I'll come on to deal with this, because I know that your Lordship asked me yesterday to do so, but the extent to which Blackpool could exercise control in how various paid, unpaid volunteers went about their work for Blackpool was inevitably more limited than if this had been an employer-employee relationship.
What could, looking at that paragraph, what is the vestigial degree of control that Blackpool Football Club did have over Roper?
As his Lordship said in his judgment, he could have refused him access to the club. He could have said to him, if he didn't like the way he was going about his work for the club, or going about running Nova Juniors, he could have said, we're not going to take any of your boys, and the whole arrangement would have ended. Boys would have gone elsewhere.
Can I ask you quite bluntly, what's that got to do with abuse on a tour to New Zealand operated by Roper?
Because that was all part of the same of the role he had in recruiting the best talent. It was another step in that. This was him reviving Nova Juniors.
But does that go anywhere beyond simply saying that the fact that he was a scout gave him the opportunity which he took?
He was known as a Blackpool scout.
That doesn't quite answer, well, it doesn't begin to answer my question.
My submission, this is I think what the judge concluded, and my submission rightly, was that the tour to New Zealand was all part of the recruiting process. He set up, when the boys came back and liked playing together, he set up the Nova Juniors. And Blackpool, not directly in the sense of calling the tour Blackpool Tour, but they were complicit in that. They agreed to do it. They were aware of what was going on. The meetings with the parents took place in their social club. And they sent, or rather apprentices at any rate, went on with it, albeit out of season.
Have I got that right? Tour of New Zealand was part of the recruiting process, and Blackpool were complicit in the happening of the tour.
They were for the reasons that I said. Perhaps complicit,
Yep.
unfortunately.
The fact you've been through them.
Yeah. Complicit does sound rather sinister. I don't mean it in that way at all. We're supportive of the tour, considerably supportive. And there's an echo of paragraph 22. Finally, if I may, in Lord Reed's judgment in Cox. Lord Reed then says the remaining factors listed by Lord Phillips. You'll remember that there were 5, namely, tort will have been committed as a result of activity being taken by the tortfeasor on behalf of the defendant. Tortfeasor's activity is likely to be part of the business activity of the defendant, and by employing the defendant will have created the risk of the tort committed. Those factors were, I think he went on to say in the passage, were likely to be more significant. And that's echoed, not a change in the way in which the court should regard vicarious liability, because there was none, but it's echoed by Lady Hale in the Barclays case. If you go to paragraph 215, her ladyship at paragraph 20 refers, first of all, refers to Cox and the Ministry of Justice, which of course refers to the Christian Brothers case, and the 5 policy factors identified by Lord Phillips, and then cites the passage that I have read out, and then refers to Lord Reed's paragraph 24, which I didn't read to you. The result of this approach is that a relationship other than one of employment is in principle capable of giving rise to vicarious liability, where harm is wrongfully done by an individual who carries on activities as an integral part of the business activities carried on by a defendant and for its benefit, rather than his activities being entirely attributable to the conduct of a recognisably independent business of his own or of a third party, and where the commission of the wrongful act is a risk created by the defendant by assigning those activities to the individual in question. And I'm going to come back, if I may, to deal with those three factors in a little while. The judge, as I said, did deal with control in paragraph 161 of the judgment on page 113. This is the third and last paragraph of his conclusion, third and second last paragraph of his conclusion on stage 1. He says it's true that Roper seemed to control Chapman more than Chapman controlled Roper, but Blackpool could have removed Roper's access and all the other instances of his position with Blackpool at a stroke, and if it did, Roper would have been nothing. He depended on Blackpool FC, even though he was not employed by them under a contract. He couldn't do what he did without them. They gave him the tools to do his work, the credibility to make promises about them, the perks to buy allegiance to them, and the association to build loyalty to them. At any time, they could have taken all that away, refused him access to the club, stopped his association with Chapman, and made it known that Roper no longer had any influence over the selection of boys for schoolboy forms or apprentices, and then he would have been finished. And then he deals with the integration point, perhaps, rather than so much the control point. So the ultimate control lay with Blackpool. And it is a classic case, in my submission, of control over what he could do, but not how he could do it. And if I may say so, that where in the way in which he dealt with control was not the principal reason for his conclusion that there was a relationship capable of giving rise to vicarious liability, nor in a case like this can it be. And I say in a case like this because the club's impecuniosity meant that they had to use volunteers to help run the club to a great extent. Hurst was one, Roper was another, and there were others as well. Indeed, it's only the senior staff who were paid, Ellis, Chapman, and so forth. As was the case, as is the case in any case like this involving volunteers, such as scout leaders or elders in the Jehovah's Witness Church. These are volunteers, they're not paid. And inevitably, the control that someone who's dependent upon volunteers has, in the sense of telling them how to do their work, was much looser. And in those cases, the focus of the test, as in any event is the case, because as we can see, the importance of the control element is much less than it was. The focus of the test is the extent to which Roper was bound up with achieving the overall aims of the organisation. And there was nothing more fundamental to the survival of this club, survival and success of this club, than to have good talent from wherever it came. Significantly, of course, Mr. Bardsley and Mr. Stewart came from Nova Juniors South Manchester. One just has to think to oneself, where would they have gone if there hadn't been a Nova Juniors in South Manchester run by Roper? They would, of course, have gone to what are much bigger clubs in that area.
I don't think that we can make a judgment on that, can we?
I'm not asking you to do that, but the whole point of having Mr. Roper where he was to try to source talent from that area of the country, and others did it from nearer to home. And having considered and set out the correct legal test, the judge went through all of those cases to which I've taken you. The judge was entitled to conclude on the facts of this case that stage one was established, namely that this was a relationship which was capable of giving rise to vicarious liability. In particular, he held, in a manner which I would submit cannot be legitimately challenged by this appellant, because these are findings of fact, that although Roper had not been paid by Blackpool, this was because at the time of the index events, the club was financially stretched, and very few people could be paid. And it was in that context that identifying, recruiting, and retaining the allegiance of promising young footballers was part of the core business of the club. The recruitment of talented junior players was central to its business interests. And of course, as we heard from many witnesses, became central to its financial survival. It was the saviour. The sale of those players saved the club from extinction. And of course, it was Roper who'd introduced Stuart and Bardsley to the club, and Mr. Chadwick told his lordship that it was no exaggeration that the sale of those two players, those were his words, had literally saved the club. But for Mr. Roper's involvement in scouting and recruiting, the club would not have survived. And he was central to the development of youth players at the club, a core component of the appellant's commercial operation, one of the key business activities of any sporting club, as the judge described it in paragraph 159 of his judgment, no more important task for the club. Mr. Ellis said in evidence that the club was, to use his words in cross-examination, largely dependent on Mr. Roper. And Mr. Mr. Ellis said that Nova Juniors was a feeder team which was exclusively for Blackpool. Now, neither of those assertions were challenged in the evidence. It wasn't suggested otherwise. And with respect, he wasn't just some wealthy benefactor, valued only for his or her money. He was somebody who played a hands-on role, which was just as important to the club as good coaching. And this wasn't simply a case of a scout who made the occasional recommendation to a club, which led to a young player being recruited, which was suggested by the appellant and suggested indeed by Mr. Hurst in his evidence. The evidence was, of course, that Roper's feeder team was one of several feeder teams, but much the most successful in terms of providing young talent. And I've reminded you already of the evidence that the judge heard about from CFS about the numbers that signed in any particular year. When considering stage one as a whole, the judge was entitled to and properly formed the view that the relationship between Roper and Blackpool was one akin to employment. His detailed reasoning is set out at beginning at paragraph 159 in a detailed passage continuing on 160 to 162. And put another way, going back, if I may, to those three factors which Lord Reed said in Cox were the most important in paragraph 22 of his judgment in Cox. First of all, factor one, the assault was committed as a result of activity being taken by Mr. Roper on behalf of the club. He was central to the recruiting processes, even if he didn't have a contract of employment. There may have been others who performed similar roles, but not as successful as he did. And as a result of this, he was highly valued by the club. He put himself forward as a scout and was well known to everybody as being one. He not only put himself forward as a scout, Mr. Ellis's evidence was very important about that, but all the witnesses recall that this was his role. So that's factor one. As a result, assault was committed as a result of activity being taken by Mr. Roper on behalf of the club. The judge found, and was entitled to find, that this was part of the recruiting process. Factor two, Mr. Roper's activity was not only likely to be, but was part of the business activity of the club, and there's a certain amount of overlap between those two factors in this case, perhaps. Recruitment of young players was a critical part of the business of maintaining a successful football club, without which it couldn't survive, and his work for the club was a valuable part of that process. And then finally, importantly, by, in inverted commas, employing Mr. Roper to carry on that activity, Blackpool created the risk of the tort being committed. It was Mr. Roper's position of authority and status, his aura, as Mr. Ellis described it, which allowed him to have close contact with vulnerable young boys. Had he not been a scout for Blackpool, then the abuse would not have occurred, because he wouldn't have built up a relationship with DSN, who wouldn't have been going on the tour. And that relationship was one founded upon the status, respect, and authority which his position at the club conferred on him, but which equally created the risk of the claimant being vulnerable to abuse from someone like Mr. Roper. And had his trips to New Zealand, or this particular trip to New Zealand, not been endorsed by Mr. Ellis's presence at the Tangerine Club and speaking to the parents, with the assistance from the youth players, and by a donation from the club, then DSN quite simply wouldn't, Roper quite simply wouldn't have been in a position to take advantage of the respondent in the way that he did. And I do say that the relationship was a very much closer one than, for example, between a defendant and an independent contractor, such as the doctor carrying out medical examinations in Barclays Bank. And it's not surprising that the trial judge formed the view he came to in circumstances where Roper had been central to the youth team operation for very many years. There was evidence before the judge that his involvement with the club began in the 1960s, I think, not in the same role. He started off at the club as a sort of, to use the witness's word, a gopher, and he moved on from there. And in my submission, the judge's conclusions on stage 1 are clearly satisfied. They were an appropriate and accurate application of the law which existed and can't be faulted. So going on to ground 8 rather, the judge's trial approach to stage 2. DSN was abused during a tour to New Zealand.
This is following your skeleton argument.
Yes.
Counsel, pretty much word for word.
It
doesn't help us if you're just reading it out.
No, I'm slightly conscious of that. So far as stage 2, which I think we spent quite a lot less time dealing with, much of what I would say, all of what I'd say, I think, is contained within my skeleton argument between paragraphs 29 and 35. And for speed, I'm more than happy to leave it at that.
What are we to make of the fact that the judge simply didn't refer to or appear to take into account the other aspects of this trip, like Thailand, such as the fact that Roper paid for it, so that on any balanced view, there are distinct elements of this being a Roper enterprise, subject to endorsement by Blackpool, but and the British Airways docket has the same sort of approach. Yep. And that there is nothing in the limited contemporaneous evidence, documentary evidence we've got, that describes this as a Blackpool trip. Speaking for myself, I have to say it's a well-crafted judgment. It's closely reasoned along the line of reasoning that it follows.
Yeah.
But I am troubled by the fact that there doesn't seem to have, particularly when you come to stage 2, there doesn't seem to be any acknowledgement of the fact that there is even another argument.
First thing to be said is, of course, as you would have expected, those points were well made and forcefully made in submissions and in the course of the evidence. And the judge doesn't deal with everything that was submitted to him. The conclusions that he reached on stage 2, which I haven't dealt with in detail, but are contained in effectively paragraph 175, are closely thought out. He says, I'm picking it up, this is page 116. He says, I suppose it's in the fourth line, Blackpool, given its inadequate resources, was never going to be able to run this as an official trip, but it was as close to an official trip as made no difference. It was a football tour that was part of Roper's operation in building the allegiance of promising young player footballers. I won't read it all out because I know that your lordship has it. He doesn't deal with each and every point that was made either by me or by a learned friend in submissions, but he does come to a view in my submission which was perfectly reasonable on the evidence that he heard. This was a trip which was arranged by Mr. Roper, but it was not challenged that there were, as I've taken you through already, the Blackpool did take steps to support it and to give it their stamp of approval. And certainly he was paying for it, and he may even have had his own reasons.
That's the £500.
£500, yes. Not a huge amount in the scheme of things, but nevertheless a payment to recognise the role that he played at the club. It wasn't going to be anything like all of it, although of course it may be the case that Mr. Roper got a return on that investment from his activities in Thailand. He does deal, I think, with the fact that they went to Thailand and so forth. He doesn't address that in the concluding sections, but he's obviously conscious of that.
Well, he records it when his review of the evidence.
Yes.
In the same way as he records the further visits, but his reasoning is in paragraph 175.
Yes, it is.
Could you just help me on this?
Yes.
Your case concentrates heavily on the perception of others. And I think it's in Barclays that the Supreme Court was invited to widen the test, to turn it into a test based upon the perception of the reasonable person. And they expressly declined to do so. What implications does that have for your case?
If this were a case where there was any where Mr. Roper was telling people that, but it wasn't something which the club was aware about, then that might be a good argument. The club can't be responsible if somebody puts himself forward as a scout without their authority or approval. But this is far from that case. Everybody knew that he was known as a Blackpool scout. So whilst one can see that how that argument may have force in certain cases where the defendant is saying, we didn't know anything about his saying that he was a scout for Blackpool, we've got nothing to do with that. That's not this case.
Well, it could have been if they were saying, he's now saying that this trip is run with a view to Blackpool Football Club's better interests. They may have said, no, hang on a second. We are reassuring these parents, vis-a-vis being parents ourselves who are sending our children on the trip.
Yes, but everybody knew he was a Blackpool scout. That was what he was. That's what he was to everyone.
Well, he was a Blackpool scout when the father of Kevin, Mr. Sharp, refused to let him go on a trip to Thailand because he said that's not a football trip.
Well, quite.
But it doesn't mean that he wasn't then known as a scout for Blackpool. And my lord's point is that this tour involved quite a substantial time in Bangkok.
Extraordinary.
Well, it's extraordinary if it's a Blackpool Football Club tour.
Well, to an extent we're going around the houses because I don't say it's a Blackpool Football Club tour. I'd say it's part of the process of recruitment. This was how he determined he would entice these boys away from their clubs and their genius was to be set up afterwards.
But a key part of the judge's reasoning in 175 is that it was as close to an official trip as made no difference.
Yes.
So that is saying that equivalent to a Blackpool Football Club tour.
Yes, and I think he's speculating, but thinking about all of those things that I have been through already about the support that Blackpool gave for it. But there are aspects of this which don't fit with that proposition. But he referred to them all in evidence, and in my submission came to a conclusion which was a reasonable one.
I'm really sorry that we keep holding you back.
No.
Do you think you're going to finish within the next 20 minutes or so, because we've got to give Mr. Kent the opportunity to respond.
I'll do my best. I'm going, if I may, to move on to limitation. If your ladyship and your lordships are happy for me to rely upon what is set out in the skeleton on stage 2, unless there's anything else. And I'll move through it swiftly because, to a great extent, it's contained in the skeleton, if I may. We're backwards in the skeleton to paragraph 3.
Yeah.
First of all, in fact, the skeleton wrongly refers to the appellant as the respondent. That should, of course, be the appellant erroneously defines the central question for the judge as whether and to what extent the defendant was prejudiced in meeting this claim as a consequence of a lengthy delay in commencing proceedings. And we've made the point, which probably isn't improved by repeating it, that that is not the correct legal test. And the judge did apply the correct test. You can't simply look at the prejudice to the defendant. What you need to do is to balance the prejudice which might be caused to a claimant in not disapplying the limitation period. So, in other words, not allowing a claim to proceed, compared to the prejudice to the defendant and, in fact, to the claimant, in terms of the extent to which either party might be handicapped in defending a claim by the passage of time. I've referred in paragraph 7 to the judgment of Lady Justice Smith in Kane and Francis, and just, if I may, to identify that this is a balancing exercise, and that the extent to which one takes into account prejudice may be affected by the extent to which there is a good reason for the delay. And what her ladyship says there in the passage in gold, there may be some unfairness to the defendant due to the delay in issue, but the delay may have arisen for so excusable a reason that looking at the matter in the round, on balance it's fair and just that the action should proceed. And then she puts the other side, the balance may go in the opposite direction, where there are no good reasons, or no reasons for the delay. And this is precisely the test that the judge applied. And then I've referred to the very helpful judgment of Sir Terence Evans across the roles in Carroll. I won't take you through it because he deals with a number of important propositions. But then at number 9 of the page in my skeleton, he says, his lordship says, the reason for the delay is relevant and may affect the balancing exercise. If it has arisen for an excusable reason, it may be fair and just that the action should proceed despite some unfairness to the defendant due to the delay. And then he deals with an appellate court only interfering where the judge has made an error of principle, such as taking into account irrelevant matters. And the judge carefully looked at that, and without taking the court through it, he was in the best place to evaluate the totality of the evidence which he had heard. And he came to the conclusion that the delay was entirely excusable, being caused by the tort itself or its consequences. And that's an entirely different situation from a claimant who either isn't able to provide an explanation for the delay or an explanation which is only partially excuses the delay. And coming back to what Lady Justice Smith had said in Kane and Judgment, in such a situation, it's much more likely, when considering reduction or loss of cogency in the evidence, that the court would exercise its discretion appropriately to disapply the limitation period. Again, I'm taking it quickly because I know the court has read it. But paragraph 14, the judge deals with the evidence of paragraph 50. He is entitled to take into account a remarkable number of witnesses, both youth and adults. The material time gave a great deal of evidence on issues which were strikingly consistent and cogent. He's entitled to do that. I refer to FZO in the Court of Appeal, in which that is made clear. Conclusion, picking it up at paragraph 16, which the trial judge reached, was one to which he was perfectly entitled to come. Indeed, I would say he was right to come. Where the appellant in my submission goes wrong is simply to look at one side of the balancing exercise, namely the potential prejudice which it faced. That's an important part, but only part of the picture which the judge has to take into account and balance.
But if the judge was wrong on the issue of of prejudice, doesn't that flaw the balancing exercise?
Well, it tips it more in favour of whichever party is substantially prejudiced. Yeah.
But at that point, it becomes difficult for you to say, well, it was a matter of discretion for the judge. He had to carry out the balancing, because if he's got some element wrong in the balancing.
Yes, it's a matter with respect for the judge to determine the extent to which a party might be prejudiced and put that into the balance. And against that, of course, is the prejudice to the claimant of not being able to bring his or her claim. It's part of that balancing exercise. But my submission would be he looked carefully at the evidence, asked himself the right questions, and came to the conclusion that there wasn't sufficient here for him not to exercise his discretion to disapply. And he deals with he specifically deals with the absence of Roper and Chapman in his judgment at paragraph 59. I don't underestimate the significance of their deaths. I have to say, the suggestion that Mr. Roper would have given evidence in a trial, whether it be in the 1990s or whenever, it's really verging on the fanciful, not least because even if he were back from where he disappeared to, either as a party to the case proceedings or as a witness being called by Blackpool, the prospect of his getting into a civil court, which may have consequences in terms of the inevitable prosecution which would follow from the evidence that had been heard in that would have been nil. The real point that is made is that Mr. Chapman wasn't available. The judge considered that carefully and came to the conclusion that on the principal points that wasn't sufficient to tip the balance in favour of the defendant. And if one looks at those, can I just by way of example, take you to his conclusions on stage 1, to demonstrate how, as he said in his judgment, the issues were quite narrow, the factual issues were quite narrow. Paragraph 159 at 112. So this is the first paragraph of the vicarious liability conclusion. And if one just poses for a moment the question of, well, to what extent would Chapman's evidence have made any difference to these findings? Whether, picking it up, Roper was an unpaid volunteer, but the club's dire financial state meant that almost all the non-playing staff were in the same position, Ellis and Chapman being the exceptions. There's nothing that Mr. Chapman would have said would have made any difference to that. That was common ground. Chapman could not and did not do his job alone. He depended on people like Roper and Hurst to help him. And in doing what he did, Roper was very much doing the work of the club. Again, with respect, that subject, I suppose, to the expression he was doing the work of the club was common ground. He was working. He was part of the recruitment process. chaplain didn't do his job alone, there was no more important task for the club than spotting and capturing young players and bringing them into a position where they were willing to sign up for a lower division club side with limited resources. That's an observation which the judge would have made in 1995 as Mr. Justice Griffiths did in 2020. This is the task that Roper did better than anyone else, and everyone knew that he was doing it. Mr. Hurst accepted that when I took him through the sheer numbers of people who came from Nova Juniors every year. He was a Blackpool scout, and his Nova Juniors side was a Blackpool feeder team. Its sole purpose was to take boys, so far as possible, into a closed environment in which Blackpool had a better chance than any other club of securing their signatures. That was the evidence of Mr. Ellis, the club manager. Then there was evidence that some boys didn't take the bait, and DSN himself didn't sign for Nova Juniors after the New Zealand trip. But on the evidence, they were the exceptions. Roper was very effective, and both the number and the quality of the young players he brought to Blackpool was exceptionally high. So my submission that his lordship was quite entitled to say to himself, as he did, that actually the issues, the principal factual issues on which he's made findings are mostly common ground. And that, of course, is a factor which he's entitled to take into account. And one could carry out the same exercise in relation to his conclusions at stage 2, which are at paragraph 175. And so, in my submission, the judge's findings on limitation are sound and well within the generous ambit of his discretion, going back to Sir Terence Everton's comment on appeals. The judge is in the best position to make a conclusion about that, having heard the evidence, and I would invite you to be very slow indeed for overturning a decision based upon the exercise of the judicial discretion, which is very evidence dependent. Well, I've cantered through that, and if there's anything I can assist your ladyship or your lordships with.
No, thank you very much. Thank you, Mr. Counsel. Mr. Kent, do you follow?
Yes. No,
I'm sorry.
Thank you. Mr. Kent.
Yes, my lady. Can I just say something about my learned friend's submissions on control based on the authorities? Because he fairly acknowledged that control, though it may be said to have lost some of its significance, hasn't lost all of its significance. And of course, we've seen the way in which what matters is whether the employer or quasi-employer can tell the tortfeasor what to do, even if he can't tell him how to do it. But my learned friend then says, well, what do you do if you've got an organisation which relies upon volunteers, perhaps because he can't afford it? And as I understood it, he was suggesting that one could move away from even that control test of what to do. We respectfully say that can't be right. After all, this is a test of whether it's fair, just, and reasonable to impose liability on a no-fault basis on a party who, on that hypothesis, would have had no control over the wrongdoer. And what we say the cases show, where you get to an akin to employment situation, where they are volunteers, for example, the Jehovah's Witness case, the XB, where the headmate says the elders were integral to the organisation and the nature of their role was directly controlled by it and by its structure. Or where you have Boy Scouts or Scout Masters, where they submit themselves to a structure of a disciplined organisation where they are prepared to, as it were, take instruction. Or the De La Salle Institute, where they take vows to follow orders. You have at least you have control in fact, even if it may not be contractual. And even if you have a contract of employment, the employee could walk off the premises, and there's always a limit to the control you can exercise. But there is at least a situation where you can say that the tortfeasor was carrying out was part of the organisation because he or she was doing what the was carrying out tasks assigned, and I'm using the word of I think Lord Reed, assigned to them by the employer or quasi-employer. So it's not good enough to say, well, it's all very difficult to apply these tests if you get to a pure volunteer situation, because that will be a way of saying, well, these criteria just don't work, and therefore forget them. But they're the very essence of this of the policy reason why there is a no-fault liability imposed, not just in pure employment cases, but in cases akin to employment. And my learned friend also relied upon, in relation to control, I think it was the only aspect he could rely upon. There was no other evidence, and he doesn't point to any. Relied upon what the judge said at 161 of the judgment, which is that the club could have withdrawn their permission to let Roper come to games, matches, and so on, attend the premises. And he would have been nothing, so the judge was not quite true. He would have carried on with his business. But that's an entirely negative point. That's not saying, demonstrating the club could tell Mr. Roper what to do. It can be tested in this way. Imagine the consultant surgeon who has an appointment with the NHS, who is at a hospital where he works, permitted to see private patients. The hospital trust could, of course, withdraw that permission at any time. But that wouldn't be enough to say that if he negligently treats his private patient, the NHS hospital trust is then vicariously liable for his negligence. It's a purely negative point. And so we do say that the evidence and the findings demonstrate that that key ingredient is simply not present. Returning to points made yesterday, my learned friend slightly modified it today, but it accepts that the case that this was a Blackpool Football Club trip, starkly put in the pleadings, what wasn't made out. And he said yesterday, well, the case had moved on from the pleaded case. Well, not quite with respect. It is true that it was always part of the claimant's case that to bolster and explain why the trip to New Zealand was an occasion which imposed vicarious liability, that the surrounding circumstances were addressed, which is that Roper was a scout for Blackpool, and witness statements were served showing his relationship with Blackpool. We accept that, and we had to address that. But nevertheless, the case, that was the evidence in support of a case that this was a Blackpool Football Club trip. When that case failed, we say that was the end of should have been the end of the case. But in any event, the rather complicated approach, which has now become clear is being adopted, both by the judge and by my learned friend, which is that you have to go back to Nova Juniors, South Manchester. He said, my learned friend said yesterday, its purpose was to provide Blackpool Football Club with a steady supply of players, and that was its sole purpose. That is mere assertion by my learned friend. How does he support it? He partly refers to Frank Sharp, but he's after the event, and he'd never heard of Nova Juniors, South Manchester. And then he refers to Mr. Ellis, paragraph 7, page 111 of the supplementary bundle. But Mr. Ellis said two things of significance. Firstly, he'd already said that he left the youth side of it to Jack Chapman. And in paragraph 7, significantly, the sentence begins, as far as I was aware, Nova was a feeder team solely for Blackpool FC, and Roper did not introduce players into other clubs in the northwest or further afield. But we know from evidence, which I've already referred to, that he seemed to be happy to refer players to Manchester United. That was that example. And although my learned friend hasn't addressed the question of the unagreed material, but if we come to the question on the question of prejudice, of course, in paragraph 69 we quote police statements which refer to Roper apparently having connections with other football clubs. And then Mr. Ellis in his statement referred to Roper being the coach of an affiliated feeder team, but as I took the court to Ellis's evidence at page 161, I asked what he meant by that, and he said he didn't really mean anything by using that expression. So this expression feeder team, which does not appear in the pleadings at all, but is used by a number of witnesses, seems to be no more than saying that this was one of the junior clubs, and my own friend has acknowledged today that there were a number of others which introduced good players. The Nova Juniors was a particularly successful one, it is said. In fact, that's based on, I think, two players in particular who were successfully introduced. It's not clear what would be said about those other feeder teams if these coaches of those feeder teams committed torts. Is that a case of vicarious liability? Or does the position change from day to day depending on how successful the players you've introduced are? If Paul Stewart and David Barsley hadn't turned out to be successful, would that mean this wasn't a case where there was a sufficiently close relationship? It's a remarkably vague way of approaching this question. But whichever way you look at it, this is an independent enterprise. Independent contractor, we would call it if he was paid for his services. It can't be a stronger case for the claimant if he wasn't paid for the service of supplying good players. Then the cocooning point. My learned friend has addressed that, but as my lady noted in Frank Sharp's witness statement, it didn't appear there was that exclusive arrangement. We're now talking only about the Nova Juniors, the second one, the Blackpool area Nova Juniors. Frank Sharp said, paragraph 15, first of all, he said they played some of their games at Blackpool Football Club, so the suggestion that they were protected from being seen by any other professional club scouts doesn't seem to work there. And then in paragraph 20, we see that Kevin began playing after a year. Began playing for Blackpool schoolboys, nothing to do with the club. In fact, in Frank Sharp's witness oral evidence, he said at page 79 of the transcript that his son played for Nova Juniors for 2 seasons. But he was vague about the years, but he was definitely talking about 2 seasons. So it looks as though there was an overlap. And again, that's not consistent with this cocooning concept. But at all events, these sort of issues this sort of approach to vicarious liability simply underline the obvious prejudice from not having Jack Chapman there to explain in more detail what his understanding was and what his arrangements were with Roper. The notion that because there's a photograph showing a number of boys signing on a particular day in a particular year for Blackpool Football Club, that somehow supports the notion that this was an exclusive arrangement wouldn't satisfy any test of statistical significance. Maybe in 7 out of 10 or 7 out of 9 boys in that year, but we have no idea. If you take a 5-year run, that may, for all we know, it may have been 7 out of 50, or it may have been more out of 50. We just don't know. In any event, why is that any different, we ask rhetorically, from, let us say, a teacher at a school who proudly has lined up for photograph in the headmaster's study the 5 pupils who've got into the same Oxbridge College, let's say. It is no more than that. And this brings one back to the point of control. You can be a feeder team, just as you might be a feeder school in the broad sense of the word, that an organisation may rely upon you to bring talent to your organisation, but you are, unless you have some exclusive arrangement and have some power over that, some right of preemption, as it were, you are simply waiting for them to, and hoping that they will continue to patronise you, as it were. Limitation. The point is shortly that we accept it's all the circumstances, but there's clear prejudice. But the learned judge thought there wasn't, we suggest, because he thought that a much broader approach to vicarious liability was appropriate. In any event, it's not a trump card to say, well, there's good reason for the delay. As Lord Brown said in A. N. Hoare, we quote that at paragraph 9 of our skeleton, there may well be cases where a fair opportunity for the defendant to investigate the allegations is likely to be found quite simply impossible after a long delay. And so it must be acknowledged that whatever the reasons for the delay on the part of the claimant, that's not necessarily the end of the matter. And this is a case where, because of the complexity of the way in which it's seen that it's now being advanced as a case of vicarious liability, where the lapse of 30 or more years, and my own friend referred to evidence going back to the 1960s, does make it quite obvious, we submit, that the defendant must be severely prejudiced in seeking to meet, to investigate, and then meet the case being put when, nearer the time, clearly, the recollections would have been clearer. A good example of the fallibility of memory, no criticism of the claimant himself, was that he thought Kevin Sharp was at the School of Excellence. His father said he wasn't. So that's an inaccuracy. And the evidence is littered with inadvertent inaccuracies from people doing their best to remember things so after the event. So there's obvious prejudice. Lady, if I could turn my back for a moment, see what I've forgotten. Yes. Thank you. There is one. If I could just take you back to one passage in the transcript, page 169. This is in fact in re-examination by my learned friend of Mr. Ellis. And it illustrates my point that the club may have been reliant upon feeder teams, including this one. This may have been a particularly good feeder team, and he may have been a good scout. But the club had to wait for him to decide what he would offer. So right in the middle of the page, why would the club have been pleased that he was associated with the club? Answer: well, because of the players he brought. He had a good reputation. It seemed he only wanted to bring the best players to Blackpool, so they had first choice of a good group of players, and so on. And then further down, just above letter G, letter F, I think you told Mr. Kent that your view was the youth system was dependent to a large extent on Mr. Roper's involvement, without a doubt. Can you explain to his lordship what you meant by that? Yes, because his team, and I emphasise the word his, contained some of the best players from the Manchester Stockport area. It would have been looked at by the big clubs in Manchester. Frank preferred to bring them to, I think he probably preferred to be a big fish in a small pool. So there is Mr. Ellis saying, well, we were lucky. We had someone who wanted to send good players to us and not to some of the better-known clubs in Manchester. But that's the very negation of control by Blackpool Football Club, or Roper being part of the staff or part of the workforce, being told what to do. The club had to wait with bated breath for him to bring another good player if he chose to do so. Unless there are any other matters.
No, thank you very much.
Can I just answer the question that the Bishop asked about convictions? The sanction, I'm told that Mr. Roper was convicted on the 6th of March 1984 of indecent assault of a male under 14, for which he was made the subject of a 1-year probation.
Right.
94.
84.
84.
Yeah. Thank you very much. Thank you, Mr. Counsel. We will obviously reserve and get a draft judgment to you as soon as possible. It would be very helpful, please, if there could be a joint response in terms of typographical errors. As you know, it's not an opportunity to make further written submissions. Perhaps a draft order could also be submitted at the same time, and any ancillary orders that follow on from the terms of the judgment. If those applications relate to costs, I don't think we've had a schedule from either side so far, so they will have to be put in good order, please.
Does your ladyship require a schedule for summary assessment because of costs? The reason I asked that is that it was listed, I think, for more than a day.
Of course it was.
So we decided to...
Yes, so if it's just indicated whether there's any argument.
Oh, a cost argument.
That's better.
I'm sorry.
Yes. No, Mr. Kent, it was my fault. My
Yes.
Clumsy use of language.
Yes.
And it only remains for me to thank all members of the team, and I don't just mean leading counsel and those who sit behind them, Mr. Futrell and Mr. Bradley. But it's undoubtedly the case that both sets of solicitors have done an awful lot of work on this, so thank you all very much.
Might I mention just one matter of timing? I think this is probably something that we're both interested in terms of your judgment. Of course, the reason I ask is that there is a trial starting at the end of October, last week of October, which is listed for 8 weeks, involving Manchester City Football Club.
Right.
And 8 claimants. The legal teams are the same as now, and it may not be possible to do so, but it would be of great assistance to us if we were able to have the judgment before the end of October.
I think you will.
Thank you very much.
I do think you will. I thought you were going to ask me if it could be before the end of tomorrow.
That would be helpful.
Well, don't hold your breath on that one.
I will.
No, but thank you all very, very much indeed.
All right.
Thank you.